Guthrie. I'm a professor of law and the dean of Vanderbilt Law School. On behalf of the law school, I'm delighted to welcome you to the 14th Cecil Sims Lecture. Dedicated to Cecil Sims, a member of the Vanderbilt Law School class of 1914, the Sims Lecture is an important endowed lecture series that has featured, among other prominent speakers, 5 U.S. Attorneys General and 4 U.S. Supreme Court Justices. Several members of the Sims family are with us today. Will you please join me in thanking them for making this lecture series possible? Today I am honored to introduce Justice Stephen Breyer as the 2010 Sims Lecturer. Justice Breyer holds degrees from Stanford, Oxford, and Harvard Law School. Following law school, Justice Breyer clerked on the Supreme Court before taking a position at the Department of Justice and then Harvard Law School. Justice Breyer taught at Harvard from 1967 to 1980 when President Carter appointed him to the U.S. Court of Appeals for the First Circuit. In 1994, President Clinton appointed Justice Breyer to the U.S. Supreme Court, where he has served with distinction for more than a decade and a half. Earlier this year, Justice Breyer published a book entitled Making Our Democracy Work. You might have noticed a few copies around the law school. In contrast to his work on the Supreme Court, which is not subject to review, his book has been subject to review, and favorable review at that. The New York Times, for example, called it, quote, a brave book. In it, Justice Breyer is building an argument for the ages, not a strategy for the coming term. His book makes clear that judges, however modest or restrained, have an indispensable role in making government work. Likewise, the New Republic describes Justice Breyer's book as constitutional interpretation for adults and observes that it is Justice Breyer's openness to opposing points of view and his recognition of the difficulty and necessity of trying to balance them that makes his message urgently relevant and a kind of balm for our polarized age. Today, we are pleased that Justice Breyer will deliver his urgently relevant remarks here at Vanderbilt Law School. After Justice Breyer delivers his remarks, he will happily take questions from audience members. At approximately 1 o'clock, I will conclude the proceedings so that the justice can take a breather before teaching a class in this very room at 1:10. Will you please join me in welcoming U.S. Supreme Court Justice Stephen Breyer to Vanderbilt and to Nashville?
Thank you, Dina. It's a very nice introduction, and thank you, Sims family, for this lecture, and the judges. I appreciate their coming, and the mayor and the students. And it's true, it's not true. I did not come here to Nashville because I have a song I am trying to. But I wanted to come here, and I want to talk about this book. Now, a colleague of mine once on the First Circuit gave me an article he claims was written by an archaeologist who said that they had found a tablet from the city of Ur written 10,000 years ago, and when they translated it said, things are not what they used to be. It said the transportation doesn't run on time, children will not obey their parents, and every man is writing a book. Well, there we are. And that's what I'm going to talk about. Why did I write this book? That is a good question. I think because Harry Blackman, who was my predecessor in office when I was sworn in, made 2 comments very directly to me, just personally. He said, first, he said, you'll find this an unusual assignment, and that is true. He also said, you'll discover there is a kind of unquenchable thirst among Americans to know what you do on the Supreme Court. What is it? I mean, most people in America know there is such an institution, but not all that many know what you do. And no matter how many times you explain it, you're just talking to a very small number of people, and there will be lots more who would like to know. And he said, do it when you get a chance. Try to explain to people what it is you do. And that's what I'm trying to do. I'm trying to explain what the job is like. And I have to see it through my own eyes. I don't have any of it. And so it naturally has whatever biases I bring to this job. But I think it's a good way of trying to get across to people who aren't necessarily lawyers or even law students or judges what it is, this institution. And of course, the reason that Harry Blackman wanted me to discuss it is because you need the public's understanding if you're going to get the public support. And in a democracy, if they don't support at least the existence of the institution, it won't exist. So there we are, and that's a problem. And as you well know, it's become more and more of a problem. I went to see that movie the other night. What is it, Social Network? Have you seen that? Well, it was harder for me to understand, you might think. But it's quite clear we don't have a Facebook page. So how are we going to get this across? Well, I've told some stories in the book. I have a sort of method here. The stories, in a sense, are Mary Poppins. A little bit of sugar helps the medicine go down. But this is what I'm trying to do. So I found a couple of organizing questions. And the first question, which strikes me anyway, is more and more interesting the longer I am on the court. I put this way. So why should it be that 9 of us who are not elected have, in a democracy, this is a very old question, why do we 9 who are not elected have, in a democracy, the power to set aside a law of Congress made by people who are elected? Now, that's a very old question, which I'm sure they discuss in your constitutional law classes, and the fact that it's an old question doesn't make it a bad question. And why? So my own response to that, what's this? All right, can you hear me without, oh, I forgot to turn it on. Could you hear me? Anyone who couldn't hear? Oh, wait, is there another room of people? They couldn't hear me. How could they hear me? I was speaking loud. All right. Anyway, I'll turn it on. There we are. This isn't as bad as when I was speaking somewhere and whoever the moderator was, it was a fairly good-sized audience. Turn off your cell phones. Okay. 3 minutes later, my cell phone rings. There we are. But anyway, this was what Hamilton was looking at, this document, the Constitution, and he wrote in Federalist 56, he gave his reasons why he thought, and he did think. It wasn't John Marshall who made this up. He did think that the Supreme Court would have the power to say that the Constitution trumped an ordinary law. Now, why, he said, should the Supreme Court have that power? Well, first, he says, if they don't have the power, you see this document? If somebody doesn't have the power to say when a law or an action of another government official violates this document, if no one has that power, well, here's what we should do. Let's put it up in the National Gallery. Let's send to the Metropolitan Museum of Art. Maybe here there is a great museum of music. Well, we could hang it up. There we are. People can look at it. It'll be a work of art, but of no use whatsoever. So somebody has to have the power to say when an action of another government official or a statute violates this document. He says, who should that be? The president? Well, the president he thinks is too powerful anyway. And if he has the power to say with whatever he does is constitutional, that's going to be a problem. They'll be too powerful. A tyrant possible? No. Well, what about Congress? They're the ones who are elected. He says, let's think about that one. I mean, Congress? A lot of these provisions here are designed to protect people in circumstances where they are very unpopular. And one of the whole points of the document is that the least popular person in the United States should have exactly the same rights under this document as the most popular. So now let's think. Will Congress set aside a law that it just passed because it was popular in order to protect the rights of those who are unpopular? Maybe. But he says members of Congress are experts on popularity. They are. They know all about it. And if they didn't, they wouldn't be where they are. But that means they're not going to be so willing to set aside an action that they just took on the ground that that action violates a provision of the Constitution. Where doing so is not a popular thing to do. But we have another group. These sort of anonymous bureaucrats over here. I mean, they're pretty gray. They do their job. They're judges, and so probably they know something about law. And what's wonderful is they don't have much power. They don't have the power of the purse. They don't have the power of the sword. Perfect. We'll give them the job. They won't really interfere too much, and they'll try to do their job, which is a legal job, basically, deciding when a law or something other action violates these legal provisions in this document. Perfect, done, and most of that constitutional convention agreed with him. That's what they thought would happen. So it happened. But he didn't ask one question because he didn't know the answer. And I think that's a pretty good organizing question. Now, it's Hotspur's question. I mean, Hotspur, Henry IV, Owen Glendower comes in. He's a Welshman. Now, for Shakespeare, every Welshman is a mystic. So what Owen Glendower says, he says, I can summon spirits from the vasty deep. And Hotspur, who's a good practical Englishman, says, well, so can I. So can any man. But will they come when you do call for them? Exactly. And he never asked that question. If these people are so obscure, if they're these 9 gray judges, alias bureaucrats, if they have no power of the purse, they have no power of the sword, why will anyone do what they say? Well, he doesn't know the answer to that question. And it took a long time before we can be reasonably certain of the answer. And I do want people to see, through a few examples, of how difficult a question that was to answer in the history of the country. So I've started out here with a case. It's a wonderful case, and read in retrospect, it wasn't wonderful for the people at the time. The Cherokee Indians. The Cherokee Indians own northern Georgia. There are 2 treaties. These treaties give them northern Georgia. And unfortunately for them, gold was discovered in northern Georgia. This is in the 1830s, and the Georgians thought, well, why should they have that gold? Why shouldn't we have it? Good point. So they took it. Now, that wasn't so good from the Indians' point of view, who were, they were not hunters, actually. They were farmers. They had a constitution. They're indistinguishable. And so they did what any civilized group of people would do under such circumstances. They hired a lawyer. And they hired a good lawyer, the best one of the day, Willard Wirtz. And he said, don't worry, no problem. Read the treaties. It's your land. And after a lot of ups and downs and so forth, they got this case to the Supreme Court. And the Supreme Court, in those circumstances, had to answer it. And they did. And they said, John Marshall said, Joseph Story said, yes, it's your land. It's the Indians' land. No problem. Now, you may have heard of this case. For this reason, it is about that case that Andrew Jackson, the president, supposedly said, John Marshall, the Chief Justice, has made his decision. Now let him enforce it. And Andrew Jackson sent troops to northern Georgia, but not to enforce the decision. The troops were sent to evict the Indians. And they left and followed the Trail of Tears, called that because so many died en route to Oklahoma, where their descendants live to this day. That's not a happy beginning. The court didn't hold anything else. Didn't hold anything unconstitutional, really, until Dred Scott, which is one of the worst decisions ever written, probably the worst. But anyway, we'll stay away from that for a while because I don't have time. I want to jump ahead. A point that shows you a difference directly with the Cherokees. And I can remember this one. Some of us can't. This is after Brown. In 1954, the court decides Brown versus Board. It reads the Constitution, which says that no state shall deprive any person of equal protection of the law. It considers segregated schools. And for someone of my age who can remember before Brown, in order to see whether this was equal protection of the laws or not in the South and maybe other places too, all you had to do was open your eyes. And at that point, the court says, it does violate the Constitution. There will be no more segregation under the law. The 14th Amendment forbids it. That was 1954. Brown 2 is decided a few months thereafter. And then what happened in the next year? Nothing. No, let me be fair, not completely nothing. Next to nothing. The District of Columbia did. President Eisenhower got that desegregated, and they were doing some preliminary steps in Topeka and other places, but not much. Next to nothing. And another year goes by, nothing times nothing is nothing. And Governor Shivers in Texas, faced with a court order to integrate the schools, said, I'm not going to do it. And after that, what happened was nothing. All right, it is at that point that the Little Rock School Board orders, because the school board wanted it, goes to court, and the court orders what the school board wanted, which was integration of very modest, but integration nonetheless, in Little Rock. And the first place was going to be Central High School, and the 9 black students prepared to go in, known as the Little Rock 9, because they're pretty brave, they were getting ready to go in September of 1957. As I say, I can remember. And at that point, Governor Faubus, figuratively, he stood in the schoolhouse door and said, those black students will not enter this white school, and you can have all the judges you want, but I have the state police. And they're not going to come in. And there were quite a few groups around that school. There were the White Citizens Councils, and people came from all over the state and elsewhere in order to stop the integration. And a picture was taken by a news photographer of a woman white woman face in rage when looking at the young black girl who was going to go into the school, Elizabeth Eckford. And that picture went around the world. Well, it was not a good situation. The congressman from Little Rock, Hayes Brooks, or Brooks Hayes, he made an arrangement with President Eisenhower. And Faubus agreed to go up to see him. The governor went to see him at Newport, where he was for the summer. And he hadn't gone back yet. And later, Governor Faubus said that President Eisenhower dressed me down like a general dresses down a sergeant. He told President Eisenhower, he said, okay, I will allow integration. And he went out and told the press the opposite. So President Eisenhower was not happy. But he did consider force, the military. And he talked to many people about it. He talked to the governor of South Carolina, Jimmy Burns, who had been a member of the Supreme Court, was a close advisor to Presidents Roosevelt and Truman, and was not a bigot. But he said to Eisenhower that if you send troops to Little Rock, you will have to reoccupy the South. Are you prepared for that? You will have to have a second Reconstruction. The best that will happen, the best, is they'll close the schools and nobody will be educated. Is that what you want? Well, Herbert Brownell, who was the Attorney General, was giving him conflicting advice, contrary advice, and said, you have to do it. You just have to. And Eisenhower himself had seen, he'd grown up, he wasn't willing to tolerate, possibly the biographers say, some segregation until World War II, where he saw where it's segregated units. Bill Coleman told me this, who was probably involved in that. He said that Eisenhower saw the performance of the black battalions at the Battle of the Bulge, and that's what convinced him. This is ridiculous, and he was determined he was going to end it insofar as he could. All right, insofar as he could. But he decided to do it. He would send the troops. And he sent the 101st Airborne Division. Now, again, to my generation and older, that meant something. The 101st Airborne Division were the troops that had invaded paratroopers Normandy. And they had gotten wrong instructions, and some of them were hanging up on the steeples where they were shot down by the Germans, and they overcame that. They were the heroes of Normandy, and they were heroes again at the Battle of the Bulge. And in 1957, almost every American knew the name, the 101st Airborne. And he took 1,000 troops, put them on airplanes, they flew to Little Rock, and the next day they took those 9 black students, and they walked right into that white school. That was a great day for law in America, and it was a great day for America. The pictures were taken. They were sent around the world, and I wish I could say it all had a happy ending, but it didn't. Then Cooper and Aaron began to come up through the courts because the school board got cold feet, and they didn't want to continue this, and it went to the Supreme Court, and eventually the Supreme Court, 9 signatures on a single opinion, very rare, And those 9 signatures all said, but you have to do it. But 9 judges. You could have had 9. You could have had 90. You could have had 900. You could have had 9,000. Where are the troops? And the troops didn't reoccupy. They did withdraw. And the day after that opinion came down, Governor Faubus closed the schools, and nobody had schooling at Little Rock for the next year. It was bad for them, if you read their later biographies. Very bad. But, in my opinion, an opinion of historians who know more, that was a turning point. Of course, it did not immediately bring an end to segregation, but it was a turning point. And lots happened after that. There were Martin Luther King in the 1960s and all of the marches and a lot of different things. But from the law's point of view, that, to me, was critical, that those troops were sent to uphold the law. So when I had to show a Russian paratroop general around the court, the State Department had called up because this paratroop general had been in charge of missiles, which had been pointing at the United States, and he changed the direction. So the State Department said, we should be nice to this man. So I took him around the court, and he was saying, I told him, what cases did I think were particularly important? I told him about Brown, but I told him about this case because it's meant always something to me about the practical needs and the difficulties of enforcing an unpopular decision, certainly then, and I thought it was very important. I said, what it shows is that the paratroopers and the judges must be friends. Something to that. All right, now let's roll the cameras forward again. I mean, think you want a very important decision, think of Bush versus Gore. All right, now, I was in dissent, so I thought it was wrong. I said, I didn't think we should take it. I was fairly strong. You shouldn't take it. We should dismiss it. And if we are going to decide it, let the recount continue. That was my view, and the view of 3 others. But 5 thought the opposite. All right, so I thought it was wrong. But one of the most interesting comments I've heard about it was Senator Harry Reid, who brought the senators come over sometimes to the court. They bring the new senators over, and the leader gives a talk. And he was talking about that case, and he said one of the most remarkable things about the case is something that's very rarely remarked. And that is, despite the fact that it was very important, and despite the fact, in his view, at least half the country thought it was wrong. I thought it was wrong. Despite that, people followed it. There wasn't rioting, and there wasn't violence in the streets. And that, he said, is a treasure. And I agree with that. I think it is. Now, always guarantee in this room, I've said this before, and I guarantee there are at least 10% of the people who are thinking, no, they should have rioted. It would have been a good thing. All right? Say, all right, violence. And I know that's what they're thinking. And when I say, well, all right, you turn on the television set. And you see what happens in countries where they settle their disputes by killing each other. See what happens. And then ask yourself again, whether in a country of 300 million people, where there's so many differences, that you really want that as a way of resolving major disputes, even if courts will sometimes get it wrong, as I thought they have. By the way, the 5 think they were right. Don't forget that. And there we are. You see, that is over time. I want you to see, whoever is willing to read this or listen, I want them to see that it is not a done deal that we follow a rule of law, that following a rule of law has meant a history where sometimes it was followed, sometimes it wasn't, and if you read the cases in detail, you end up with a degree of uncertainty as to how much it was and how much it wasn't, and to what extent would it be, and can it be, and what's involved, and it's all very complicated. Good, I'm glad it's complicated. That's what interested me about these cases that I've picked out in order to illustrate this point. They are so complicated, and that the whole situation is. So that you will think that it isn't up to me to decide what's going to happen in the country, in this respect, in the next 50 years. It's up to you. And unless people understand what's going on, they won't do it. And if they don't do it, we lose it. All right, that's the very simplified message. Now, I have to admit there's more to the book than that, because I want you to see also how we decide cases. So I've said this. I've said so far, I've told you something about the relationship, something, if you can work it out from these examples, of the relationship between the American public and an independent judiciary and a rule of law in the country. But there's more to that than the public. There's also the court. And what are the court's responsibilities in this respect? The court, by the way, cannot guarantee that people will follow its decisions. I mean, this is primarily a job for teachers, for teaching civics in the classroom. When I read that they're not teaching civics in high school, I say, my goodness. And Sandra O'Connor's on a big crusade in that respect, and I agree with her. Of course you have to teach civics. Of course you have to teach the generations that are coming. And that's the generations that are following you. You're already here in law school. I mean, it's going to be, you don't even think of that, but I mean, there will be generations following you. And they are going to have to know something about this. So that's where that responsibility primarily lies, but the court has a role too. You say, well, what is the court's role on this? And beware, because you're so tempted to think, and that's what I want to fight. It's so tempting to think. I'll tell you another thing people are thinking. This is, they won't admit it, but this is what they're thinking, and this is what I want to fight. They're thinking, I'll tell you how the court decides things in these controversial areas. I'll tell you how. This is inside. They won't say it out loud while I'm around. Politics, that's what it is. These are 9 junior varsity politicians. That's what, and believe me, junior varsity would be the word. And that's how they decide it, and I want to fight that and say that can't be, it shouldn't be, it isn't, and if it is, we're lost. And the first, that's why I skipped over Dred Scott. Because the best that can be said for Dred Scott, which is terrible, they said a black person whose ancestors were slaves is not a citizen, can never be, etc., and held 15 different compromises unconstitutional, and it was a terrible nightmare. But if you were looking for something to be said for it, it was that Roger Taney and the court majority at that time thought they were stopping the Civil War by assuring the South that slavery would never be taken away from them. Well, if that was the political idea, it was a terrible one. Not morally, it was morally too, but not just morally. Because, in fact, what happened after Dred Scott is it produced a total nightmare of criticism. Mostly from the North. The South liked it, but mostly from the North. But it was devastating. And they printed up Curtis's dissent, and they sent it around the country, and one of the readers was Abraham Lincoln. And Abraham Lincoln took that dissent and used it in many of his debates, and used it in his speech at Cooper Union, which helped make him the leader of the Republican Party, which helped commit the Republican Party to an anti-slavery position, which ultimately led to his election and assured a civil war, in fact. So if Roger Taney thought he was avoiding a civil war, he got it exactly backwards. And that's why I say that generalize from that, generalize, and you'll say, among other reasons for not having judges hold their fingers to the political wind, is they're terrible at the political wind. They know nothing about it. They think they do, perhaps, but they're wrong. And they're likely to get everything wrong. So, of course, if they were deciding it politically, of course, if they were deciding it on political grounds, one, they're likely to get it wrong, and two, what's the point of this whole enterprise, since Hamilton put the power in the courts primarily to avoid the political nature of the decisions that would be made were it in Congress. So, I mean, if you're going to decide on a political basis, give it to Congress. Ah, but you say, well, you're just telling me what should. What about what is? I say, what is? My experience, not political in the political sense. I need about 3 hours to tell you why I don't even think Bush v. Gore was that, but I may not convince you, but I don't have the 3 hours, so take my word for it for the moment. And go on to other things. I'll say, no, it's not political. Political is, are you Democrat, Republican, popular? Where are the votes? No. You say, but I didn't really mean political. I really meant that you have all these judges up there, and they're just doing whatever they think is good. Try that one. If you try that one on 9 judges, you'll get 9 different views of what's good. And if you try it on 900 judges in the whole federal system, you will get 900 different views of what is good. Good. You have given me a new recipe for something that just cannot work. You say, okay, How are you going to avoid that? And here I'll summarize a little bit, but I think this is where lies the strength of a view which I don't hold, but a view which many hold, which is called originalism, which is a view that what we do is we find out what the framers thought on any given point by going looking to history. Now, I personally do not think that's a good system, but those who hold it think it's a good system because it will keep the subjective impulses of the judge under control. And then I have to respond to that. And I say, I don't think you can because the history is too uncertain in almost all these cases. That's just one reason. And, you want to have the history decide everything, let's get 9 historians, not 9 judges, and you'll discover the 9 historians are fighting about the various points on which these cases turn anyway. And besides, if you could go back and discover that the framers of the Constitution thought it was a great idea to flog people and so forth, why would we want to buy into such a system? Fine. But the person, Justice Scalia, disagreed. He takes this view. And one of his best arguments, if I can produce many responses, and I put some of them in the book, but he says this: remember the story of the 2 hunters who are out camping, and one is putting on his tennis shoes. Where are you going? He says, there's a bear. He's coming. The bear's coming. He's chasing us. He says, don't be ridiculous. You can't outrun a bear. And man looks up and says, yeah, but I can outrun you. All right, so that's the people who want this originalist to just say, well, it may not be perfect, but it's a good approach. To which I'll say, okay, I better show you there is something different. And what is the something different? The trouble with the something different is it's a little complicated. And what I hope the court will do here, and what I hope the students will do, and what I hope the teachers will do, will be to try to understand it, and it's not original with me. So let's go back to American history. And you'll see Gordon Wood has a book which is interesting on this, and he says go back to 1780 and see what the judges thought of their own craft. The words they used to describe it in 1780, there's a great one from Connecticut, Jesse Root, and he says the American judicial tradition is a tradition of prudence and pragmatism. All right, what does that mean? I say, well, I can tell you in the constitutional area what it is I think I'm doing. I think what I'm doing is taking values in that Constitution, freedom of expression, that stands for something important. It's an important value. And the value doesn't change, but conditions change. So if I'm applying the Commerce Clause, I have to apply it to a world where there's an internet. And indeed, there is transportation that the framers never dreamt of. And if I'm applying the First Amendment, I have to apply it to a world where there's an internet. And there's Facebook, and there are movies like, what is it called, Social Network, which I couldn't even understand. I better, if a First Amendment case arises, because what we are basically doing, I think, or should do, and we do it to a large degree, is you take those values that are written into that document and you apply them to circumstances that no one then ever thought of. When there were 4 million people in the country, it was a different country in 1780 than it is in today when there are 307 million. And indeed, the same values can govern. But the same conditions are not there. That's not such an easy thing to do. But now, so far, you might say, oh, no, this is good. I like this. This sounds right. Fine, great. It's a great 4th of July speech. Go give it on the 4th of July. But do you really do it? How do we know that there is a way of doing this? And that's where I try to go into some detail. Now, it's already 25 minutes to 1, so I can only give you an example. I mean, I want to show students particularly, I want them to see how you might use this kind of approach to deal with statutes. I say I'm talking about statutes. I'll say every judge in this room or any room who has to interpret a statute has a difficult job. We wouldn't have the case in the Supreme Court if there had not been other judges who looked at the words right there and they interpreted these words in different ways. So by definition, they're difficult. But all of us have the same kinds of tools. We all read the text. Now, if the word in the text is vegetable, that is not a chicken. A chicken is definitely not a vegetable. I don't care what the purpose is or how much good is done, you cannot call a chicken a vegetable. All right? There we are. Text. And you have history. Who wrote statute. And why? History. Tradition. Suppose it says habeas corpus. Well, that has a big tradition, those words, and you better know it. Precedent. Usually there's some this way and some that way by the time it's in our court, but you better read the precedent. And then what I've called values or purposes. Why did Congress write those words? What was it trying to achieve? And then look at consequences. And the consequences are not just any old consequence in the world. They're consequences that have to do with that text. Consequences that have to do with that purpose. Consequences that you look to see if I interpret it this way, am I furthering the purpose or am I hindering the purpose? All right, everybody uses those 6 things. Some people think just emphasize the first 4, text, history, tradition, precedent, and some, probably me, think let's look very heavily, put a lot of weight on purposes and consequences. All right, differences in approach, no. Differences in weighting, different factors, yes. Or I'll give examples. I've given one from administrative law of how we go about that. And the administrative law buffs, namely Lisa, my former clerk, who was very helpful giving me good ideas, and she has found 14 others in this whole law school who will listen to this subject. No, we love administrative law. We are in it. I have a part on that. And then just to give you an example, so give you something really difficult. How would you approach this? This is terribly interesting and very difficult. I'm talking about other branches of the government. So when I talk about the statutes, I'm talking about Congress and the courts. When I talk about administrative law, I'm talking about the executive branch and the courts. What about the president and the court, where the president has a job that's really his almost personally? It's not this great bureaucracy. At least it's not our typical administrative law bureaucracy. What about the president, foreign affairs? What about the president, war power? What about the president in times of national security? Where the president wants to take action, and the court, after all, has to look to the document. And a lot of words in that document have to do with, even if it's unpopular, giving civil rights of important sorts to everybody, the most unpopular included. How do we deal with that? I mean, that's not such an easy question. Why not? Well, I grew up in San Francisco. Sorry to say this here. I was coming back from Texas, and I was afraid to point that out because they have some sympathy for the Rangers, while someone who has grown up in San Francisco has a different view. But the point there, if we go back to where I grew up in San Francisco, is I can remember my mother driving me down past Tan Foran Racetrack after World War II, and she pointed to that and said, that's where they held the Japanese. The look of approval was not in her eyes. I mean, in 1942, this country took, the Army took 125,000 Japanese, 70,000 American citizens of Japanese origin, and moved them involuntarily from the West Coast to camps in the eastern part of California and in Intermountain area. How could they do that? Well, they did it because we were afraid of an invasion from Japan. That I can remember. I can remember the blackout curtains. But 1941, December, the harbor. This is January, 2 months later. And there was concern that the West Coast would be invaded. All right, General DeWitt, who's in the Presidio, thinks one important thing to do, supported, by the way, by Earl Warren, who later said this is the worst thing he ever did. He was sorry he did it. But lots of support in California for taking everyone of Japanese origin and just moving them. 5th column. That's what the newspapers wrote. And President Roosevelt signed an order, and they did it. And they did it. This came to the court in 1944. It came in the case, primarily the case, of Fred Korematsu. I met Fred Korematsu. It was interesting. Famous case, Fred Korematsu. I met him because, by chance, my next-door neighbor in Cambridge, Massachusetts, was the daughter of an old friend of my father's from San Francisco named Ernie Besig, who had been the head of the ACLU in San Francisco and represented Korematsu. Oh, I can't believe it. I don't. All right. I forgot to turn it off. Turn off your cell phones. Anyway, see, it won't go off. There we go. God, I don't know how to work these things. How am I? There we go. All right. Anyway, Bezig, by the way, represented Korematsu without the title ACLU because the ACLU wasn't willing to do that in San Francisco. I mean, later they did. They got on board. But I mean, it gives you a little idea of some of the mood of the time. But Bezig representative, and Korematsu was told by his parents and family, don't do this. They didn't want to rock this boat. And he said, I'm doing it. He was a feisty guy, even at age 80 when I met him. And he was great. I liked him very much. And he said, I'm bringing this case because this is America. He gave a little talk on it, which I put in here because it was very good. He said, they can't do it. They can't do it. And eventually it got to the Supreme Court, and Korematsu lost. And this is 1944. There were 3 dissenters. There was Jackson, Roberts, and Murphy. But it's filled with interest. I'll get to that. Why? One thing was there were 2 lawyers in the Justice Department, Ennis and Burling, and they didn't like what was going on one little bit. And one of them had read an article that had been a public article in Harper's Magazine written by the head of the Office of Naval Intelligence, I think it was, and he said there was no need for this. There was absolutely no need. This was wrong, and they had the situation under control. So he went to read DeWitt's report. DeWitt, remember, was the general in the Presidio who had ordered this, and he'd written a long report saying why he had done it, and a part of this was because there'd been signaling, 763 instances of signaling to Japanese submarines, and there'd been 5 instances of sabotage. So Ennis and Burling get the FCC. They go to the FCC and say, will you look into this? Give us a report. What happened with all this signaling? They said the same thing to the FBI. 2 weeks later, the FCC comes into their office with a stack of stuff like this. And he said, well, what is the result? He said, the result is there was not one instance of signaling. Almost all of those, almost all, were just buck privates having just gotten into the Army. They didn't know how to work the equipment. And the others, we've tracked every one, 0. He said, well, that's amazing. How do you do it so quickly? And they said, oh, we didn't just do it. This is documentation that we did in January and February of 1942. And we gave this to DeWitt. So he knew this at the time. FBI, same thing. The one person who had told DeWitt, we really don't want this, J. Edgar Hoover. He said, we know who the people are that we need to suspect. And there are plenty of them. There are 1,000, but not 70,000. He said, we know who there are. Not 70,000, not 125. Don't do it at the time. So they wrote a footnote that they wanted to disassociate the Justice Department from the briefs or from the report of DeWitt, and to make a long story short, it was all compromised out in the department. But the footnote was there. It was just incomprehensible. And even though it was incomprehensible, Charlie Horsky, who was the lawyer for the ACLU, in oral argument said to the court, read that footnote. And he told them exactly what it meant. All right. So now we have a court that knows about the footnote, knows this wasn't really justified then or now. And Jackson says, even if it was justified then, let's set it aside now. I mean, it's perfect. The military, if they need to, can act unconstitutionally to save the country, and then we will tell them they were wrong and save the Constitution. Well, that's a nice soundbite, but I don't think it works. But regardless, he was in dissent, which was okay. But the people in the majority, Black, Hugo Black, the greatest civil libertarian of the century. Douglas, Frankfurter. I would say, why? Why did they do that? And I think the answer, and this is all just to underline the difficulty of the question that I started with, is they think, well, someone has to run this war. Roosevelt or us. And we can't. So he has to. So we'll give him free rein. Very few today think that that case is right. But it's not so easy. So when does it come up again? In my mind, it comes up again in the 4 Guantanamo cases. And this time, the courts turned to a different result. In this time, we have Among the four plaintiffs, bin Laden's chauffeur. Bin Laden's chauffeur is not the most popular person in the United States, perhaps the least. And he's suing the President of the United States, the most powerful in the free world, and he wins. And if you look at those four opinions, I think my characterization, I just sort of set out what the court held and what the arguments were against it. But my own characterization is they're trying not to repeat Korematsu, but also with the recognition, as Jackson said, and people have said since then, the Constitution is not a suicide pact. It is the case that the president may well need authority of an unusual sort where the security risk is great. And the result is four opinions that please nobody. Four opinions that on the one hand try to hold the president accountable, but the real civil libertarians say they certainly didn't go far enough. And on the other hand, the people who are worried mostly about security say, why did they get involved at all? There we are. So I want to set them out because I want people who see it to see the difficulty which I feel, and I don't know if I can communicate that or not, but in cases like that, I am at a kind of abyss. I mean, it's a void. I mean, there we are. And you don't want to say, I didn't want to say, certainly, and I didn't say. And I joined opinions that said the opposite. The president can't be held accountable. On the other hand, lots of recognition that this could be a serious situation. Terrorism is not made up. That's the recognition in the opinions. And so what do? Hold the president accountable in time of war. How? Very narrowly. How? Writing opinions that may be focused. Well, you'll have to see that. But all I'm trying to do there is to give you or the reader or others the idea of what it is like to try to manage the relationship between courts or Congress or the president in the circumstances which require the courts to do what Hamilton asked the court initially to do. To be there when there is concern for enforcing a part of the Constitution that gives the same rights to the most unpopular person in the United States as to the most popular. And I want people to see the difficulty. I'm not feeling sorry for myself, but I want them to understand the nature of the problems because I think by doing that, I can help a little small amount relieve the tension that you get from reading the accounts in the newspaper all the time, which is what this case was about, was the good one about the bad one. The good one says this and the bad one says that. And so we have the bad one fighting the good one, and we are hooray for the good one, whoever you happen to think it is. And that's called seeing it as all political and seeing it as all an argument when it isn't an argument. It is more problem solving of a very special kind than it is an argument. And why do I want to do this? I'll repeat it. The reason I want to do it is because I think that it's important to get public support for the institution, and the way you get public support for this institution is certainly not to always do what the public wants. So the public has to support an institution that will, by definition, be most needed when it's doing the very thing they find horrible. That's why it's unpopular. And by the way, these are 9 human beings. They're 9 men and women. They are not angels. And therefore, it could be that their decision is wrong. And quite a few at the time think about each controversial one that it is wrong. So there we are. We have the man or the woman who is going into the supermarket because she has a family to feed. They have 2 jobs. They are trying to figure out the kids to school. There may even be some practice after school they have to go to, and they're tired when they come home. And I'm sort of now think about the Supreme Court. That's not such an easy thing to do. I don't really have a captive audience that I can sometimes get in a law school. But I think it is helpful if I do it. It's helpful if you do it. It's helpful if the lawyers to the editorial boards and say, when you have time on the law day, we'd like to tell you something about what we do. And it's helpful if the law students also take it a responsibility eventually, or maybe now, to see that the community understands that you're part of it, and you are part of it, and you are part, and that you do take an active role in the democracy, because I've said this 5,000 times, but why not once more? Because I think that document foresees that you and every other citizen will participate in the government. And so in doing that, I think you shouldn't forget to try to explain to people what it is you're doing and why it might help them, even if they think it's unpopular. All right? Now you have the book. Thank you. We got 10 pieces. All right. All right, we have 10 minutes, so we had 50 minutes, so I've proved what Ken Galbraith used to say. If there is a professor and you wind him up, or her, and set her talking, it'll be 50 minutes, whatever the subject. And if you have questions back there, please, or anyone, you can ask whatever you'd like. Don't guarantee to answer it, but yes, sir, yes.
Thank you for coming, first of all.
Thank you.
So many would assert that the liberal bloc, if you want to call it that, on the court is up against one of the most activist and conservative blocs in modern history. I'm wondering, to the extent you can discuss this, so many of the decisions are 5-4 nowadays, like Citizens United, but then also cases that seem less politically charged, like Free Enterprise Fund. And I'm wondering, do you think these decisions that reflect such kind of a deeply divided court will diminish the public acceptance of the court's legitimacy going forward? And if so, what can be done to solve that problem?
Now, that's a very interesting question and highly relevant. Remember this, probably 35 to 40% of our decisions are unanimous. Then, the 5-4s that you're talking about are probably 20 to 25%. And it's not always the same 5 and the same 4. So that's the background against what you're speaking, Then what you're also reflecting is the inevitable temptation. I wouldn't say I wouldn't have it if I were a journalist, which is to turn everything into an argument of left versus right. That's why I say it's not always the same 5, same 4, because that tends to validate the idea that this is just everybody fighting for their political views. Now, think also of what it is we're doing in many of those 5-4 cases. The way I put it into metaphor is boundary patrol. What does this document do? Basically, what it does, and I think all 9 of us agree on this, it creates a system of democratic government. That is, people through their elected representatives will make most of the decisions that affect their communities. They will decide what kind of communities, states, nation they want through the elected system. But it's a special kind of democracy. It is a democracy that protects certain basic human rights, that assures a certain degree of equality, that divides power into pockets horizontally between 3 branches of government and vertically, state, federal, and it insists upon a rule of law. So that's what this does. But if you want one word to summarize that, the word would be to create a set of boundaries. And the boundaries basically fall into those categories I've said. What's our job? Boundary patrol. When I want a metaphor, I think when I was growing up and listening to the radio, I did listen to Grand Ole Opry, Red Foley. I think it was broadcast to San Francisco on Tuesday nights, I think, or Saturday night. But anyway, Sky King of the Canadian Mounted Police, he was up in Canada on the boundaries, and it was cold up there. It's a tough job patrolling the frontiers. And now, you see, we're trying to say, is this particular instance where lower courts have divided inside or outside the boundary? Is abortion inside or outside? What about prayer in schools? What about Bush versus Gore? What about? Inside or outside? And it isn't so surprising that people disagree because there are good arguments on both sides. Now, all that has to be incorporated into your mind before you ask that question. Now, having all that in your mind, if you understand all that and have absorbed it, it's still a good question. Because what I'd say does happen, what does happen, is this. I don't think it's political. I don't think they're politically based decisions. I don't think that people are sitting there thinking what's good for anybody. They understand you can't just say, this is good. That's not law, and it doesn't work. But I do think, on many very basic approaches to the Constitution, it probably matters that I went to public school in San Francisco. It probably matters that I've had the life I've had. It probably matters to each of us by the time we reach a certain age what our past experience has been and what kind of thoughts we've had about our careers. And people do have kinds of views about, say, what the country is like and how law relates to the country. And although a president who wants to appoint somebody who agrees with him all the time is bound to fail. And that's like Teddy Roosevelt. He appointed Oliver Wendell Holmes. Oliver Wendell Holmes, within 3 months, had dissented in the Northern Securities case, contrary to what Roosevelt wanted, and Roosevelt said, I could appoint a judge with more backbone carved out of a banana. And he was annoyed. But if you're looking for general philosophy, what's the relation of law to the people of America? What kind of country is it? And how does all this sort of work? Very general level. You might get people who basically share, if you're a president, your very, very general views. Well, do I think that's terrible? No, I think that's fine. I think that's fine. See, as I said, I grew up in San Francisco. I lived for 35 or 40 years in Boston, and I thought I met a lot of people who disagreed with me on things. I didn't know anything. Wait till I got to the Supreme Court of the United States. There you see people who really do disagree. They really do, honestly. And they're serious people. And they thinking these things through. And I think first my reaction was, why would they disagree with me? My second, more sensible reaction is this is a very big country. There are 307 million people, and they think a lot of different things. And it is not a bad thing that you have 9 members of the Supreme Court of the United States who, on these very basic questions of philosophy and general view, outlook, do not all agree because they have long terms and different presidents will have appointed them. And that's one mechanism. It's not so for having a kind of disagreement. It's not such a terrible thing. It's not the end of the earth. If I calm the statement that you've been reading down, it's not such a terrible thing that they think different things. And over long periods of time, courts do change. Long periods. And so there is rather what I'd call a full answer, because what I think of is a very, very good question. And if you approach it with all that nuance in mind, okay, then form a view. And you see why I don't? I don't. Because what I do see in front of me every single day is I do see, as I've just said 15 times, but there's people of every race, every religion, every point of view. And I've said this 50 times. True that my mother used to say there is no view so crazy there isn't somebody in this country who doesn't hold it. And we lived, as I've said, in San Francisco. She said they all live in Los Angeles. But the point is that is what this country is. And to see people come on, I know it sounds corny, but to see them come in and they have decided to resolve their differences not by killing each other on the streets, but rather by coming into a court of law, that to me, on the first day and yesterday, I mean every day, I see that and I am emotionally moved by it. And that's what you are all becoming part of. Okay, so don't just think it's me. It's not just my responsibility. It is yours just as much, because that's what we're trying to transmit to you and then through you to 15 generations down the road. Finished. Thank you.